Hey everybody and welcome back. I hope you're all doing well. So today we're going to end up talking about Griswold v. Connecticut, which is actually a case about contraception and whether or not the government gets to tell a married couple that they can't have any. So this is actually going to be the first in a series of cases related to the same general topic, and that's privacy. It's going to take us through about 50 years all the way up into the last couple of years with Obergefell, which most of you would likely know as the same-sex marriage case. But before we get into talking about Griswold, I thought a 10-second history on contraception law, which is a turn of phrase I never thought I'd say, might be helpful to sort of set the stage for why this ended up happening to begin with. So if you go back into the 1800s, the temperance movement was starting to gain steam in the United States. Women were generally displeased with the drinking and carousing and cussing and lack of general good manners and civility of the population, which was normally blamed on alcohol and loose morals. And one of the things that they focused their attention on was contraception. They actually thought even discussing the subject was obscene, and so they went out of their way to try and get it banned. And to no small degree, they were actually successful. Individual states began passing their own anti-contraception laws, and eventually, by 1873, the Congress passed something called the Comstock Act, which, among other things, made it illegal to distribute contraception and information about contraception through the federal mail. So, if you like the idea of this string of cases, go ahead and hit that subscribe button so you get notified as to when the next video comes out. And if you like what you see, do me a big favor and hit that like button for me. It really does help the algorithm. It lets more people see the video. Always appreciate it. So when talking about this particular case, you have Griswold and Buxton, who are the two individuals at issue. And they ran a Planned Parenthood clinic out in Connecticut. They ended up actually getting arrested in November of 1961 because they dared to distribute information to married couples about how to avoid conception. And for our purposes here, that married couples point actually does matter, so keep it in mind for later. So Connecticut had a particular law in place, one of the anti-conception laws that I talked about earlier, and it made it a crime for any person to distribute articles, instruments, or drugs for the purpose of preventing conception. And there was also a law in place related to accessories and conspirators that put them in the same position as the individual doing it. The two were arrested, as I said, and convicted of this particular crime and charged $100. The court took a look at this on their appeal and came up with a general question as to whether or not the state is able to impose itself on the marital relationship regarding conception, and whether or not it could also impose itself on a doctor's relationship with that married couple on the same issue. So the court took a look at the First Amendment, actually, when trying to answer this particular question. And in particular, they looked at the cases regarding the German language back in the early 20th century. So as most of you know, World War I was a thing. We fought a few people, including the Germans. Again, it's a thing. And as a result of this particular conflict, it was considered uncouth, to put it mildly. Treason is probably a better word, to speak German, to learn German, to be German, and so it ended up becoming illegal to teach German, to learn German in the United States during World War I. Law prohibiting the teaching of German was actually struck down on First Amendment grounds. In the German case, the court found that the state is not able to contract or limit the realm of knowledge, the spectrum of knowledge. Basically, the court said that the right of freedom of speech and the press, those First Amendment rights, are not only the right to speak or to print, but that right that goes with it to distribute, to receive, to read. You cannot have the rights that are written down in the amendment itself if you do not have those extra rights as well. The court in Griswold looked at this and they made a very particular statement saying that without the peripheral rights, the specific rights are less secure. This ended up turning into a concept called the Penumbra, which is just a nice way of saying halo. From your constitutional right, this penumbra catches other rights within it, and that this light, this reach, creates a zone of privacy that forms what we generally think of as a right to privacy. As the court put it, the foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from these guarantees that help give them life and substance. Together, the court basically said that these constitutional rights with their penumbra create a zone of privacy. Looking at the Griswold case, the court then determined that the marriage relationship is so fundamental to who and what we are as individuals and our society that it falls squarely behind the shield that these penumbras form, that zone of privacy. And when the state attempted to regulate that relationship itself, rather than, say, trying to regulate the distribution and manufacture of the contraception, they were, in effect, damaging the marriage relationship itself, overstepping the state's boundary into that zone of privacy. As the court very kindly put it, would we allow the police to search the sacred precincts of marriage bedrooms for telltale signs of the use of contraceptions? The very idea is repulsive to the notions of privacy. The court was quite clear when they found that the state had no ability, because of this zone of privacy, to reach into the bedroom in search of the contraceptives. And in the end, the court struck down the law as unconstitutional, violating the privacy right of the married couple. Now note, I do say married couple, and I keep bringing that up because at this stage, that is the only group to which this privacy right is attached. It's not until the next case that we get to the single ladies. I hope you found that helpful. This was one of the more interesting cases that I read in law school. Go ahead and reach out down in the comment section below and let me know what you think. What about the concept of the penumbra, or that zone of privacy? Do you agree? Did the court get it right? Be on the lookout in the next few weeks for the series of cases coming along this line. Next up will be Eisenstadt, which will address, as I said, the single ladies issue. Until then, have a good one, everybody.